Christopher Njoroke?
Yes, Your Honor.
Simon Kagunyi?
Yes, ma'am. No. Prosecution is aware we are not.
Yeah, there's a letter dated to...
Advocates on record from the accused, I think it is before you.
Yes, I've captured.
Yes.
Trial or bond or bail to the accused persons and for their detention during the pendency of their trial. The 16 accused persons were arraigned in court on 14 July 2025 and charged for various offences ranging from Commission of a Terrorist Act contrary to Section 4.1 of the Prevention of Terrorism Act number 30 of 2012, malicious damage to property contrary to Section 3391. Informed the court that the prosecution opposed the grant of bail to all the accused of bond by number 11/2025. In the affidavit, the IO 25, he told the court or he averred that they were a crime. In paragraphs 5, 6, and 7, he describes government property that was either on issues discovered.
Before discovery, Your Honor,
Circumstances have disallowed the application by the IO for the detention of the accused persons, and I hereby issue the following orders: that each accused PN is hereby admitted to bond of Kenya shillings 200,000 with a surety of a similar amount, or in the alternative cash bail of Kenya shillings 50,000 with provision of a contact person. That each accused shall not interfere with any ongoing investigations related to the alleged offences under inquiry, and that each accused shall undertake to cooperate with investigators as and when called upon to do so. That each accused shall not seek to interfere with any witness or witnesses, either directly or indirectly, during the pendency of this case, and that each accused shall keep away from Makongeni police station and at least within a radius of 1 kilometer, unless of course when they are called to go there.
sorry, Your Honor.
I thought it would even be hard.
For visitation. Friday, they were given because they are not the people, but the visitation.
They still have their right to be accessed by advocates. It cannot be limited to certain days. They do not have the powers under any act, and I will challenge the officer to tell us which act and which provision has given them that right to limit rights and discriminate against these people. It is not right. And the only thing we are saying, Your Honor, is that let people go there, let them deal with their internal systems, but do not restrict that. For people coming to see persons charged under Porter, they will be discriminated. And not only them, now you are discriminating against their relatives, their advocates. In any case, even you will be told one day, even you, there are things you can't do.
Why?
as myself, Pierre, appear for the state, and Mr. Muge appearing for the respondent. So, Your Honor,
Has been served as usual just before you came in. Certain purported factual positions. It would only be fair for the court to test the propriety of these averments, curtailing the liberty of the subject before you, which is a very, very serious issue. And it will only be fair for you to have all the facts and test the affidavit as you'll be making your decision.
2K of the Constitution, which provides any suspect or accused person the right to challenge any evidence. Challenge evidence via cross-examination is a constitutional right that cannot be violated, and we plead for it. Detention, then Article 36A, Section 36A of the Your Honor, the final point I was making was that the application based on Section 33A.
three main reasons. One, Your Honor, there is no legal basis that has been laid for cross-examination. Counsel Muge, Your Honor, stated that Article 50 allows the accused person to confront or question or challenge evidence, Your Honor, that has been lodged against him by the state. Our submission, Your Honor, is that we do not have an accused person here. Article 50, Your Honor, makes reference to an accused person and not a suspect, Your Honor, who has not been formally charged. Been asked that the defense requires about 30 or 25 minutes or thereabout cross-examine, Your Honor, the 24 paragraphs of the supporting affidavit, Your Honor. What, Your Honor, you have not been told is the specific paragraphs that the defense wants to cross-examine the deponent on, that the applicant is seeking to clarify, and especially where it is alleged that those issues are erroneous or misleading or not true. Your Honor, you've not been told that. And Your Honor, this is not the first application that has been made before you to cross-examine the deponent. Notice, Your Honor, was served on us, as ought to have been done, of cross-examination of the deponent, Your Honor. And therefore, Your Honor, for purposes of good order and saving of judicial time, Your Honor, you're objecting, but in the event you allow, Your Honor, allow us time, Your Honor, to go and prepare the deponent.
You are actually being asked, and I'm really shocked, that one of the reasons why they are opposing is because they need time to go and coach a whole chief inspector of police.
Your Honor, I object. That is not the case. He is misleading the court. That's why, Your Honor, I am objecting. I have not said that one of the reasons. I have said if court is, Your Honor, inclined. That's what I said.
There must be decorum. When I'm standing, he needs to sit down.
I'm objecting because he is misleading.
The person who has sworn an affidavit under the Oaths and Statutory Act and say that what I have deposed is true and is within my knowledge. That is paragraph 2. How can you go? How can you go and teach someone who has already told you in this affidavit it is within her knowledge? That is what is called coaching. And that's why I'm saying, Your Honor, That you cannot be told that that is a reason to even take more time. And Your Honor, you are told that the person who has deponed all this cannot stand here and support. Your Honor, that cannot be. If it is about justice, Your Honor, this person should not be ashamed of coming and telling you, I mean what I actually have indicated here. You cannot be told now, they do it, then they hide behind the other wall, and you will proceed here. That is not just, and Your Honor, you have ruled many times. It is the prosecution that prepared this. Do you want to suggest that they didn't know that they were coming before this court? The court has, it is them who decided, even you didn't know this will come. They ought to have prepared, and that is the honor of the application.
Your Honor, I know I don't have a right of reply, but I note that you're not recording, and therefore Your Honor, allow me to just address and help reasons to allow investigations to proceed for a period of time. And therefore, Your Honor, whether or not there was recovery, that Your Honor, I believe is a question of
Where do you live?
I live in Dubai.
What do you do for a living?
I'm a medical lab technician. It's a person.
What's up?
A person.
Yard?
Mogo. Mogo company.
What is the registration number?
KDJ 14Z.
ADJ.
Yeah.
The time of 30 minutes. The prosecution can use a similar period to do the exam during the application. Tomorrow at 9.
most obliged, Your Honor.
Thank you so much. Thank you so much.